Good afternoon, Your Honor, and may it please the court. My name is David Brainard, and today I represent the defendant, Michelin Klein. The defense respectfully asks you to deny the state's motion with respect to Exhibit 31 and include it in today's trial for two key reasons. Your Honor, this is a case about witness credibility, about truth and deceit. The defendant sitting before you today is accused of suborning the perjured testimony of a witness who is now testifying against him today, Jalen Burgess. And as you know, Your Honor, that perjured testimony was not the first time that Jalen Burgess lied in a government setting. On March 7th, 2012, Burgess was indicted for welfare fraud, a misdemeanor in Imperial. Burgess submitted a signed application for welfare benefits on which they lied to the government officials, claiming that they were entitled to benefits for a child who was not theirs. Had this plot succeeded, Your Honor, Burgess would have gained over $10,000 annually in extra welfare benefits.
What is your response, though, to the state's position that there is no evidence in the record before us that this welfare application was an intentional lie and not merely an honest mistake like we see in Harris?
Of course, Your Honor. So in Harris, the facts are substantially different from today's case because Harris operated under other circumstances. The woman there didn't know that she was lying on her signed application for welfare benefits. Burgess knew, Your Honor. Under Imperial Code 1401, which Burgess pled guilty to, the code assumes that the person who signs the application knows the biological identity of their child. And if it wasn't obvious already, Your Honor, Burgess knew that that child was not their child, and therefore they weren't entitled to the benefits. Furthermore, by pleading guilty to this charge, Burgess admitted that they committed a crime of dishonesty or lied to a government official, and that makes this charge admissible under Rule 609A2.
And what is the argument with respect to the fact that this happened in 2012? Here we are in 2024, and this is old, it's stale. Why does this old charge need to be something a jury hears?
Certainly, Your Honor, and that relates to the 403 balancing test, which is mandated by Estrada v. United States. But in the case of Frazier versus Carib, we actually receive an outline of 4 different things we can look at to determine something's probative or prejudicial value. And date is one of those things, Your Honor. If the charge exceeds that sort of range of about 10 years, which it does, then usually it would not be admitted. However, in the case of Peyton, Your Honor, we have facts that are substantially similar to the facts of today's case. And that charge was, again, more than 10 years old, but it was admitted. And we ask that you would do the same in today's trial.